Hello! In this clip from our Justia webinar, Understanding Loan Transactions for the Non-Finance Attorney, Jake Rome shares his final takeaways and answers questions from our audience regarding the role of attorneys in loan transaction processes. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So now I'm going to move on and see if there's any questions.
Awesome. So Jake is here with us live today. If you have questions for Jake, please feel free to submit them through that Q&A button at the control panel at the bottom of your screen. It looks like we've already got a couple, so we can go ahead and jump right in. Okay, let me pull them up here. Awesome. The first question is, can you clarify the implications of the acceleration clause in the loan agreement and how it might affect the borrower's obligations?
Sure. The acceleration clause basically means that all the debt that is outstanding under the loan from the date of the default through the end of the term, that includes all interest and that's outstanding and accrued, plus the entire principal basically becomes due and owing at the date of the default. And this is basically a way so that lenders can either make a claim in court for the entire debt, or can even make a claim in bankruptcy if the cause of the default is bankruptcy. In essence, where the borrower normally has to make measured monthly payments, and at any given time would only have that next principal and interest payment due, it all becomes due at the date of the default.
It makes sense. Okay, our next question is, in the security agreement, there's a mention of collateral. How is the collateral determined, and what's the recourse, or what recourse does the lender have if there's a default in repayment?
So the collateral is going to be determined on a case-by-case basis. That will mostly be determined by the underwriting team at the bank. It varies from loan to loan, and it really depends on the purpose of the loan. So a lot of times the collateral will just be a piece of commercial real estate. The recourse for a default on a real estate loan, of course, is going to be the mortgage foreclosure process. Collateral can be extremely specific in terms of specific pieces of IP. Could be membership units in the actual borrower itself. For a high net worth client, that could be the brokerage account. And so the lender recourse is obviously going to depend between those different asset classes that serve as collateral.
Got it. Our next question is, I'm curious about the specifics of the loan covenants outlined in the documents. How stringent are they, and what actions could potentially lead to a breach of these covenants?
Yeah, so loan covenants are going to be pretty strictly construed, but the level of enforcement for breach is going to vary and depend on what specific covenant it is. So, for instance, if there's a financial covenant where you have to have a certain amount of cash flow to cover your debt payments, then if a borrower misses that for a financial quarter, but they come to the bank and they say, we had an extraordinary one-time expense occurring last fiscal quarter, then that may factor into the bank's decision whether to waive the violation or reserve their rights with respect to that violation. Other loan covenants are going to be even less stringent than that. Like if you have to deliver financial statements by a certain date and you're late by a couple of days, usually the bank is not going to get too upset about that. They might sit and wait and see if that becomes a pattern in practice of behavior, then you might have a problem. So they might reserve their rights with respect to those financial covenants. Other covenants, such as transferring collateral out of the borrowing entity's name, transferring title of it to a different entity, that's going to be a no-go. You're going to want to make sure that you don't do that. So the word of advice to people who are acting as counsel to borrowers is to always say, like, if there's going to be a problem and you see a covenant being breached down the road, just more information is better. Disclose early, disclose often.
Our next question is going to be regarding the guarantee provisions. What are the key responsibilities of the guarantor, and under what circumstances could they be called upon to fulfill on those obligations?
Good question. So guarantee responsibilities. Typically, a guarantee will have a subheading of being a guarantee of payment and performance, maybe one of the two, but usually both. So payment being like Bob owns a company, and for some reason the company has cash flow problems, they can't make their scheduled payment, but Bob is a person of means, independent. He has an obligation to go and make that payment on behalf of the borrower. Performance, let's say Bob owns a company, but it's managed by his friend Tim. The borrower doesn't renew their insurance policies. Tim either forgets or he refuses to do so. Then Bob, being the guarantor, will have an obligation to go and renew that insurance policy on behalf of the borrower. So these are not things where the lender has to tell Bob to do that. He knows because he signed that guarantee.
And then I think the last question that we have time for is, are there certain loan transactions that you wouldn't recommend a non-finance attorney review for their client?
Yeah, so I mean, the duty of competence always applies in these situations. If any attorney just feels like they're not up to the task or it's getting too complex, you have an obligation to disclose that to your client and either refuse the case or withdraw. There are some that are inherently more complex. If you're working on a real estate deal where there's multiple lenders and there's a mixture of debt and equity on the property and everybody has different rights to different pieces of collateral, those can get really complex very quickly, and they scale in that way. The more lenders you add in and the more different slices of the pie that you have to a certain asset class or piece of collateral. Private credit transactions are becoming more and more common now. A lot of people say we're in the golden age of private credit. So that's going to be different from your traditional institutional lender, where it's usually going to be either a fund or a corporation where this is how they make their money, is by doing private credit. Those can get very complicated quickly because it becomes a mixture of both your traditional lending deal and like a stock purchase agreement. So I would not advise for non-finance attorneys to get involved with that, because the players on the other side are very sophisticated. They usually have white shoe lawyers who represent them, and they don't necessarily have a borrower's best interest in mind, because they are in a position where they can take over the business and basically squeeze all the equity out of it if they have to. And so with banks, what I represent, typically, they want to see the borrower succeed, and they don't want to overlend them that they can't support with the revenues that their businesses generate. So those types of transactions are not predatory, but like they're a little bit more adverse than what I was talking about in my CLE. So I would just be mindful of that.
And I do actually think we have a little bit more time, so we have one more question. What are some common issues you've noticed when borrowers and their attorneys might be less experienced?
I think I would like to go back to being more standoffish in terms of, like, really, I don't have any reason to not want the deal to go through. Like I was saying, we're very deal motivated. And so people being a little bit not communicative with lenders counsel, like always in the office, trust me, you can call me at any time, and not wanting to share an open exchange of information. Now, if there's like something to hide, then I could get that. But most of the time it's not. It's just are very skeptical of the reasons why I would ask for it in the first place. So I would just say, make us your friends. We want the deal to go through. Usually our clients, the banks, want the deal to go through. And so just be more collaborative. Other common mistakes will be each transaction that we do usually starts off with a checklist. And we, on the lender side, we spend a lot of time preparing these checklists. They're very detailed. And everything that's on there is necessary. There's no fluff on the checklist. So word of the wise to any attorney who is going to be representing a borrower would be to spend a lot of time getting to know the checklist. And that can save you time down the road just by spending that extra time up front. So for instance, the checklist will have all of the diligence that we're looking for. It will have organizational documents of the borrower that we're looking for, including articles, bylaw, good standing, which I brought up earlier. It will have all the diligence in terms of if there's any commercial real estate involved or residential real estate. So things like environmental examinations, zoning reports, title, prior title insurance, any of the documents recorded against the property, all that's going to be in the checklist. It's going to be even more precise in terms of if we need to get a new survey for the property. Typically, for me, there's a schedule attached to my checklist that has line by line all of the details, all the specifics of the surveys that we'll need to see in order to underwrite our title insurance policy correctly. So these are very specific. Surveys, I'm not sure how familiar any one of you are with surveys, but if you get an ALTA survey, it's going to have what's called Table A items, which are all just very specific items that will get plotted onto the survey, including plotting easements, encroachments, flood zones. It gets very detailed. All that's very important. And I've had more than once a borrower or their counsel order a survey, not check the requirements, and we have to go back and redo it. Same thing with insurance. All of my checklists will have a schedule of insurance requirements in terms of policy limits, aggregate policy limits. There are short form certificates of insurance that have to get delivered to the lender, and that will all be laid out on that schedule in terms of how the lender's name needs to be phrased. A lot of times, like if I'm representing Bank XYZ, they'll just put Bank XYZ on the certificate of insurance, when in reality, what I want is Bank XYZ, a banking corporation of Illinois, and its successors and assigns. It's these little things where if you can just spend some time with the checklist, you can head it off at the pass, and now we're not redoing things down the road, and your client's not getting mad at you. I can't tell you how many times we've come up to like the week or two before the closing scheduled, and the borrower's attorney will give us a bunch of documents, and lo and behold, the insurance certificates are wrong, and now we're chasing down third parties in order to get these small little things corrected, like putting its successors and assigns on the certificates. So if you can just read the checklist, read it thoroughly, hopefully get as much of it right the first time as we can. That way your client's happy, I'm happy, and we're not scrambling, and we all look like professionals. So that's another very important piece of advice.
Awesome. Well, thank you, Jake, for all of your insight and answering your questions. And thank you all for submitting your questions. Thanks for watching. We hope you enjoyed this video. And if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.